You're listening to the Bloom Europa podcast, a project that privileges new and independent thinking on Europe while discussing its current challenges. In each episode, we take a holistic but hard-hitting approach to analysing pan-European affairs.
Hello everyone, my name is Carlos Montenegro and I'm your host for today's show. In our fifth episode, we are talking about what are the effects of the International Criminal Court arrest warrant against Putin with Professor Sarah Nouwen, who is the co-director of the Academy of European Law in the European University Institute in Florence, Italy. Professor Sarah Nouwen brings a wealth of knowledge and experience to our discussion. She has been a professor of public international law at the European University Institute since September 2020. Before assuming her current role, Professor Sarah Nouwen served as a professor of public international law at the University of Cambridge and held the esteemed position of Fellow at Pembroke College. She's currently on leave from these positions. Notably, she serves as the editor-in-chief of the European Journal of International Law. Today, our focus lies on comprehending the implications of the International Criminal Court's decision within the realm of public international law, particularly amidst Russian war on Ukraine. Professor Sarah Nouwen will shed light on the intricate dynamics at play and provide valuable insights into this significant development. Before we proceed, it's important to note that this episode was recorded on 26th of May, allowing us to capture the most up-to-date information available at that time. So, without further ado, let's dive deep into the effects of the ICC arrest warrant against Putin with Professor Sarah Nouwen. Hello, Professor Sarah Nouwen. Thanks for joining us. We are very pleased to have you here.
It's a great honor for me to be with you.
Thank you very much. So let's start our conversation with the warrants of arrest issued by the International Criminal Court against Vladimir Putin, President of the Russian Federation, and Maria Lvova-Belova, Commissioner of Children's Rights in the Office of the President of the Russian Federation on 17 March 2023, based on the following, and I quote, pre-trial Trumba to consider based on the prosecution's applications of 22 February 2023, that are reasonable grounds to believe that each suspect bears responsibility for the war crime of unlawful deportation of population and that of unlawful transfer of population from occupied areas of Ukraine to the Russian Federation in prejudice of Ukrainian children. These under the terms of the Rome Statute. So in this context, I would like to begin by asking you to explain to our listeners how the case against Putin was constructed, considering the jurisdiction of the ICC and the fact that neither Russia nor Ukraine are members of the court.
Yeah, that's a very important question indeed. And many people see the International Criminal Court as a kind of club. And if you're a state party to that club, then you give jurisdiction. And if you're not, you're outside the club and there's no jurisdiction. But that's not entirely how it works. So the basis is indeed that the court has jurisdiction over the territory on which crimes are committed if that territory is a state party. Well, problem in this case, Ukraine is not. Or if it is committed by the nationals of a state party. So in this case, it would be, in the arrest warrant you're talking about, it would be Russians, and Russia is not a state party. Mm-hmm. There's another option, which is that the Security Council reverses the situation, in which case these preconditions for jurisdiction don't apply. But Russia is on the Security Council and has a veto power, so it's unlikely that Russia is going to allow the Security Council to refer the situation to the court. But then there's another option, and that is that a state that is not a state party can recognize the jurisdiction of the court for a specific situation. And that is what Ukraine did already in 2014. Ukraine said, we're not a state party, but we recognize the International Criminal Court to come in and to investigate here, or to look into what is going on here. So Ukraine is still not a state party, but has recognized the jurisdiction of the court.
Okay. Thank you very much. Thank you very much for your clarification on this. So, going to the next question, while Russia has strongly refused allegations of war crimes committed by its force in Ukraine, it's no secret that Ukrainian children have been relocated to Russia. Russia has portrayed this action as a commendable humanitarian effort. This February, Putin had a meeting at the Kremlin with Lvova-Belova, during which they openly discussed Russia's adoption programs for Ukrainian children in the occupied territories of Ukraine. This conversation even included Lvova-Belova's own teenage son, who had recently become part of their family through adoption. So, and in fact, on the Kremlin website, you can find the transcript of this conversation, which I tried to read and fluently translate the quotes. And I will just say one or two for the audience. You also adopted a child from Mariupol. Is this right? Asked Putin to Lvova-Belova. Yes, Vladimir, replied Lvova-Belova, to which Putin said, thanks to you. Lvova-Belova noted that if biological relatives are found, her commission would work to return the children to their Ukrainian families, whether they are located in Ukraine or another country. To which Putin replied, that's absolutely right. My question in this, it pertains to the admission and its implication in terms of the element of proof. How does it function within the framework of international law, particularly under the Rome Statute and the Geneva Conventions?
Yeah, so the Rome Statute gives the court jurisdiction over genocide, crimes against humanity, war crimes, and aggression. Now, an aggression is tricky because that's the kind of crime one would expect most, on which one would expect most now to see an arrest warrant. But that jurisdictional regime that I explained a minute ago is different for the crime of aggression. For the crime of aggression, it is required that the state of nationality has also given permission and has recognized the jurisdiction, and that's not the case here. So that's why the International Criminal Court cannot bring an arrest warrant for aggression itself. Okay. Now, what is remarkable here is that they've very quickly, actually, for ICC standards, because criminal investigations take a lot of time, they've acted very quickly. And I think that's exactly for that reason what you mentioned, proof. So if you have all kinds of war crimes, crimes against humanity, you need a lot of evidence about what happened on the ground. And doing such investigations in a war situation is usually difficult, dangerous. The Ukrainians are doing an enormous amount of work there themselves. And there are prosecutors gathering evidence, and they have a lot of evidence. Still, such cases are hugely complicated. Instead, what they've done here is a very narrow crime, a war crime, two types of war crimes under the Rome Statute, which the evidence is actually, you don't need to go to the war situation itself. These Ukrainian children are in Russia. And as you point out, the Kremlin puts the evidence on its own website.
Of course.
And that's, the type of crime is therefore different from the atrocities of which we've seen videos in Ukraine. The type of crime is one, kind of the bureaucratic crime. It's the type of Eichmann crime. It's the Adolf Eichmann, the bureaucrat who can be involved in war crimes, like this Maria Lvova, who is committing a crime just by organizing what they call a humanitarian operation.
Of course. Thank you very much. So going to our next question on regarding the effectiveness of the arrest warrant. On March 17, Kremlin spokesman Dmitry Peskov said the very question here in stake, it's outrageous and unacceptable. And he continued, Russia, like a number of other states, does not recognize the jurisdiction of this court, and therefore any of its decisions are insignificant for the Russian Federation from a legal viewpoint. As we talked before, Russia and Ukraine are not parties of the ICC. Likewise, the US, China, or India, saying some. So on this matter, I would like to ask, from an international law standpoint, what are the real effects of this decision?
Okay, so that's interesting because a decision can have all kinds of effects, political, humanitarian, economic, but your question is focused really on the international law standpoint. So what are the international legal effects? Exactly. Now, the international legal effects are mostly that the states parties to the Rome Statute have to execute the arrest warrants when the persons involved, so in this case, President Vladimir Putin or Maria Vlhova-Belova, are on their territories. Now, for the president, that until a few years ago, one would have thought that might still be somewhat controversial, because as a matter of international law, usually presidents enjoy immunity from arrest when they are traveling abroad. But the International Criminal Court, in an earlier decision with respect to the then Sudanese president, President Omar al-Bashir, has clarified its position on its interpretation of its own statute, that there is no such immunity before an international criminal tribunal. And it's likely that the court will follow the same reasoning, or has followed the same reasoning in this case with respect to President Vladimir Putin, which means that states parties would be under an obligation to arrest President Vladimir Putin. And for Maria Vlhova-Belova, it is less of an issue. Now, and this then also explains all the controversy that we currently see in South Africa as to whether or not it should invite and welcome President Putin if he wants to attend the BRICS conference that is planned for August this year. Because South Africa, according to the interpretation of the ICC, would be under an obligation to execute the arrest warrant.
And what I was actually going to ask this a little after this, but we can just finalize on this topic, not to return after. What do you think will happen and based on past cases, as you referred, what will think will happen in? I think it's in August, yes, that the conference it will be held. What do you think will happen if Putin flies to South Africa from a legal point of view? This, of course, is a theoretical exercise, but we had other cases in the past. But will South Africa say we are not anymore ICC signatory, or they will arrest, or what is your opinion based on?
Well, I'm very bad at predicting the future, but what we can learn something is about what happened in the case of Omar al-Bashir. So Omar al-Bashir did go to South Africa. Now, South Africa has a very vibrant legal human rights community, and they immediately went to court to say that South Africa was under an obligation to arrest him. The South Africans managed to get Omar al-Bashir out of the country in time, but the court did say that South Africa should have arrested him as a matter of domestic law. And then later, the International Criminal Court confirmed that it should have arrested it as a matter of the Rome Statute. Now, South Africa then said, this is not good for us, and you can understand that from a perspective of, I'm not saying understand justify, but if one looks at South Africa's role on the African continent, it really is an important actor in diplomacy, in peacemaking, and it found that such a position, an obligation to arrest, would make it really difficult for it to fulfill that diplomatic role. So it said then we withdraw from the Rome Statute. It notified a withdrawal from the Rome Statute, but then actually the South African courts found that withdrawal procedure, a bit like the Brexit decision, right?
Of course.
Leaving the EU without getting Parliament involved, in South Africa, leaving the ICC without asking Parliament was not compatible with domestic law, and therefore that withdrawal was then undone. So they're still a state party. Now the South African president has said the ANC has decided to withdraw from the Rome Statute because it would not be able to host Vladimir Putin. But then a few days later, it was said, well, no, this is not a government policy. So what will happen? I'm not sure. He may not come, but yeah, exactly.
Okay. But it's interesting to have this parallel from previous cases, because it's always sensible, and we'll return a bit regarding this topic a bit further. So coming back to the effectiveness, the audience is always questioning, when I'm preparing this topic, how the ICC can be effective without the support of major powers. This is always a question, that is on the mind of everyone that starts to read a bit about the topic. So I would like to ask, obviously it's a sum up, but I believe it could be highly intriguing for our listeners to gain a deeper understanding of the background behind the lack of signature and or ratification by countries such as Russia, China, India, and the US. If you could assist me in elaborating on this matter. Obviously on short notice, because from my perception, there are different cases, different ways to approach, and I think it would be interesting to understand specifically on these 4 countries, what is behind.
Yeah, so that's interesting. So Russia, the United States actually signed at some stage, and when you sign a treaty, that means that you express your intention to join this treaty as a later stage, so that you ratify later. And then just like Israel and Sudan, they withdrew their signatures, meaning actually we're not going to join anymore. But initially they said, well, we may join at a later stage, and they never did. I think one key explanation is sovereignty. Okay. Now, in international law, we often say, no, treaties are not against sovereignty. Treaties are an expression of your sovereignty. You can only conclude treaties because you're a state. But the United States is not known for liking international judges scrutinizing its conduct. And that, I think, is a key reason. Now, for the US, that's particularly because it often plays, whether one likes it or not. The views are differ on that point, but it plays the role of policeman in the world. And if you're policeman in the world or acting as such, of course, you're more exposed to doing things that are not compatible with the Rome Statute and therefore also subject to this court. So that's, I think, a key reason. The other reason, I think, and which is related, is that this is an unsafe court. Now, what do I mean by that? The earlier tribunals, the Yugoslav tribunal, the Rwanda tribunal, the Special Court for Sierra Leone, the Cambodian tribunal, all of them courts with the jurisdiction over international crimes, they had a very specific jurisdiction in a specific country over a specific time period, and those were safe for the powers that created them. This court is unsafe because it can also boomerang against you. And I think that's what they fear, and that's the reason why they don't want to sign up. And it's not just those countries. In a way, also France and the UK are big supporters of the ICC, but when it comes to the crime of aggression, they too wanted this very specific jurisdictional regime that I mentioned earlier, that also they must have accepted it because they did not want this to boomerang against them.
Okay. Fully understood. And catching a bit this idea of the last 2 questions. It's a very parallel question, but I think it's always on the mind. We talked about South Africa. We thought about the perspective of Western countries, of course, and China and India. But I would like to ask specifically regarding the relation between ICC and some African countries. Because it has been observed in the past that the ICC has faced some criticism for allegedly focusing predominantly on African states, while human rights abuse in other regions like Iraq, Israel, Afghanistan, and Yemen have not received the same level of attention. On this, I would like to ask if it's this statistically true, or in other words, African countries' leaders are more targeted than Western leaders, and by that affecting its legitimacy on this matter.
Yeah, so that's a really tricky one. One is look at the website of the court. Look at who are the defendants. And if you look at the defendants, you see mostly people from Africa. And I think that's a problem for the court because it suggests that international crimes in this world are mostly committed by people from Africa. And which is, if you look at what's going on in the world, not the case. So the court plays a role in distributing blame, in distributing responsibility across the world, and that image that one gets if one looks at the website is problematic. Now, why is that the case? I don't think that's the case that the ICC says, let's go for Africa. No, it's more this point what you earlier mentioned, some states are not parties, they don't have jurisdiction. But there's another point, and that's what you also refer to. You said at some stage, the court cannot do much without the support of other states. So where has the court been active is mostly in countries where states have either triggered to jurisdiction, through referrals, or where states were willing to cooperate by referring their enemies to the court. And that's what we've seen, for instance, in Uganda, in Congo. The governments referred their political opponents to the court. And that explains the situation that we now have. But in a way, and that's where this effectiveness question is so difficult and problematic. I think Martti Koskiniemi has a beautiful line at the end of The Gentle Civilizer of Nations, in which he says that effectiveness should not be a lawyer's problem, because the moment that effectiveness is the lawyer's problem, then law becomes power. You just follow the power because then you're effective. But if you want to be law principled, the ICC should go where it's most needed, is the places where there's real impunity, and that's situations where the big powers are not going to work with the court. And that will mean that the court will look ineffective because there are no people in the dock. But it's exactly for those situations that the court was created. It was not created, I think, as the court of convenience in which some states can refer their political enemies whom they would have prosecuted themselves or could have prosecuted themselves.
Thank you very much. Thank you. It was very enlightening, your reply. Thank you. And following a bit on the track on this, we have two more questions. I would like to talk a bit about a topic that is close to your heart, if I can say like this, and which is the importance of complementarity in the International Criminal Court. On this matter, I would like to refer to your book, Complementarity in the Light of Fire, the Catalyzing Effect of the International Criminal Court in Uganda and Sudan, which I strongly recommend to everyone that is listening to us. And could you tell us or explain us a bit these complex relations that we have between the ICC and national actors and this catalyzing effect at a certain domestic level?
Thanks, and thanks too for the sales pitch. So complementarity is a big term for a rule that in the European Union we know more as subsidiarity. So it comes down to the fact that the International Criminal Court cannot go ahead with a situation or a case if that specific case is already genuinely investigated or prosecuted at the domestic level. In other words, the ICC should be a court of last resort. It should take the, not the first, the first bite, but it should wait and see whether domestic courts are doing something. Now, and that principle really matters for that reason that we discussed before. The ICC was created by a treaty and not by a Security Council resolution like the Yugoslavia Tribunal or the Rwanda Tribunal. The moment that you conclude a treaty, you need to persuade states to sign up. And this was in a way, at least that's often what is argued, a way to tell states, well, don't worry, if you do things domestically, if you investigate and prosecute domestically, then we will stand back. Personally, I don't think that's the main reason why complementarity matters so much. I think what's really more important is a sense of ownership. Okay. International crimes, when they are committed as part of hugely difficult political situations. And dealing with such crimes can be very important for the way that that political community develops in the future. And the moment that you outsource that to an international criminal court, you lose all control over, and I don't mean control in the sense of political trials, but more the vision of how we should deal with accountability for the domestic situation. Now, the counter argument, of course, is that people say, well, these are not just domestic crimes, these are international crimes, and the whole international community has an interest in these crimes, and therefore they should be prosecuted at the international level. Mm-hmm. But when they negotiated the Rome Statute, a decision was taken against that argument. A decision was taken in favor of kind of the state goes first. Now, and one thing that we see, what you refer to as this catalyzing effect or catalyzing effect situation, the expectation was that states would then start investigating and prosecuting themselves. What we see is a bit of a paradox, and that has to do with this point you referred to earlier, that the ICC is so dependent on state cooperation. We often see that the ICC does a lot of cases that the state itself could have done as well, because the ICC is dependent on the state for for arresting people or for evidence. Whereas those situations that are never going to be done by the state are very often also very difficult for the ICC because it can't arrest these people. Now, the nice kind of exception, or a possible exception to this pattern may be the arrest warrant against Vladimir Putin, because it's not the case that the ICC can arrest him, nor can Ukraine easily arrest him if he doesn't leave Russia. But in general, we've seen this. I mean, if you look at more generally what the ICC is doing in Ukraine, it's not the case that Ukraine doesn't have good prosecutors. Ukraine is really, really on top of things. And what it needs, I think, more than the ICC doing a lot of cases, it mostly needs support for its own prosecutors. But when it comes to the arrest warrant for Vladimir Putin, the ICC has an advantage compared to Ukraine, which is that the ICC, as we just discussed, is not bound, according to its own law at least, by immunities, whereas Ukrainian courts would be bound by the law of immunities and could therefore not prosecute Vladimir Putin.
Okay. Thank you for your reply. So we go to our final question. It's more general, on general terms, not too legal, but it can be also. So finally, the ICC is often criticized for being inefficient, excessively expensive, ineffective. It has secured only a few convictions in 21 years of work. So considering your unique experience and invaluable expertise, what do you consider are the major areas and fields that need ICC to improve?
Well, look, who am I? I mean,
of course, it's a big finger on these matters, and obviously your input, obviously that may occur one or two ideas, I would say. But obviously, I'll let you know.
No, the thing is that, and I think that's where it comes down to. We live in a really complex world, and justice is absolutely necessary, but it's often not the only thing that is absolutely necessary, and especially not when we talk about criminal justice. There are all types of other forms of justice that are absolutely required as well. Now, the ICC can only do a very, very small part of that very complex thing that is necessary necessary to help states get to better situations. And we see that in Ukraine, right? The ICC is doing one part, but the military support for Ukraine is at least as, if not more important, from the Ukrainian perspective. And that's where you see it work. There are all these different dimensions. But I think if I have one point for the ICC, then it's more, we have to be really careful with slogans that overstate the role of the ICC. So I remember in Sudan, a decade ago or so, the ICC prosecutor said, arrest Ahmed Haroun tomorrow or today, and you have peace tomorrow. Yeah. Well, Ahmed Haroun was arrested until recently, when, because of the current situation in Sudan, all people in the prison had to be released because even the prison wasn't safe. And we don't know where they are at the moment. But it's not the matter of arresting one person. Things are so much more complicated, so much more difficult. And of course, people in the ICC know this. But this language is often used to kind of give international criminal justice more force or more power to sell it. And I think we should be really careful with that overselling, because it creates situations also where states expect too much of the ICC, and I think that's where my other point of suggestions is not so much vis-a-vis the court itself, but it's vis-a-vis the states that are supporting the court. Don't measure the ICC with this kind of standard bureaucratic checkbox exercise of, okay, that many arrest warrants, that many convictions. No, that's not what the ICC is about. And the ICC can be extremely important and successful, even if there are no persons in the dock or not the people that it wants to have in the dock, simply by doing the investigations, by doing the work, because justice often follows, not leads in political processes, as Jack Snyder and Leslie Vanjimori have argued. But justice must be ready for when political transitions happen, than to do the justice process. So I think my point would be, don't try to rush into all kinds of situations with showing, hey, we're here too. Mm-hmm. Do the work, And also for states, don't expect the court to be the solution to everything. That symbolism, tone it down and invest more in the actual work in which the court is very good, which is trying to get investigations done with a view to prosecutions, possibly at a much later stage.
Thank you very much. Professor Sarah Nouwen, on that note, thank you very much for your discussion today. It was, and to coming to our podcast, it was a truly pleasure to discuss with you all these topics related with such an interesting matter. And thanks for your time.
Thank you for the invitation.
Thanks for listening to our podcast. We kindly invite you to subscribe to our podcast, which is available on Spotify, YouTube, and other platforms. You can also check out all the links and resources on the show's notes. That's all for this episode, folks, and we look forward to you tuning in next time. This was a Bloom Europa original production.